Gene Hackman's 3 children were not explicitly named in his will, yet they may still have a claim to his estimated $80 million fortune due to legal precedents that could work in their favor. The legendary actor, who passed away at 95 alongside his wife, Betsy Arakawa, in their Sante Fe home, had all his assets placed into a living trust that he established decades ago and last amended in 2005. The specific details of this trust remain private, leaving questions about who will ultimately inherit his estate. Sante Fe probate lawyer Thomas Banner, who has no involvement in the case, explained that because trust agreements are designed to be confidential, the public has no way of knowing the terms or the designated beneficiaries. However, it remains a possibility that Hackman's 3 children from a previous marriage, Christopher, Elizabeth, and Leslie, could be included as benefactors despite their exclusion from the will. Hackman had a well-documented strained relationship with his children, and if they are not named in the trust, they may still have legal grounds to challenge its validity. If all named beneficiaries in the trust are deceased, the estate could default to Hackman's children. Additionally, an old New Mexico Supreme Court ruling may provide them with an avenue to contest the trust's legitimacy and potentially claim a share of the inheritance. A 2009 case, Chapman v. Varela, established that a will or testamentary document could be overturned if there is evidence of undue influence when it was written. If a challenger presents credible signs of such influence, the legal burden shifts to the benefactor to prove the legitimacy of the document. This precedent offers a legal framework that could be used to challenge the trust's provisions. Several factors could be cited as indicators of undue influence. These include the age and declining physical or mental health of the person when they created the document, a lack of logical consideration for the bequests, a sudden or unusual shift in how assets are distributed, active involvement of a beneficiary in drafting the will, a situation where a beneficiary exerted control over the individual's affairs, and extreme secrecy surrounding the will's existence or contents. Given Hackman's private nature, his children may argue that these factors, particularly the secrecy of the trust, indicate improper influence. Reports suggest that Hackman had been diagnosed with Alzheimer's disease prior to his death, although it remains unclear when he first received this diagnosis. At the time of his last amendment to the trust in 2005, he appeared to be mentally sound, having given a lucid interview on Larry King Live in 2004 and another with GQ in 2011. Despite this, if his children can prove that the terms of his estate planning were drastically different from previous wills, manifestly unfair, or deliberately hidden from them, they may have enough grounds to contest the distribution of his assets. The secrecy surrounding the trust is not surprising, given Hackman's reputation for guarding his personal affairs, but it could also be used as a potential argument for undue influence. If any legal dispute arises, it would likely involve claims that Arakawa, as his closest confidant, may have played a significant role in shaping the terms of his estate. Whether a courtroom battle will take place remains uncertain, but reports indicate that Christopher Hackman has already retained a prominent Sante Fe probate lawyer, possibly signaling that a challenge is on the horizon. Thank you for watching. If you enjoyed this video, please subscribe and turn on the notification bell for more updates on celebrity deaths and news updates.